Imagine, you are Utah County Judge Tony Graf. You're new to the bench, having just been appointed to the position by Governor Cox this past May, and you first took the bench a mere 43 days ago. So far, being a judge is everything you hoped it would be. Just about every day something interesting happens, and it doesn't hurt that whatever you say goes. At least in your courtroom anyhow. But today is September 16th, 2025, and what is about to happen in your courtroom is unlike anything else during your short time on the bench. In fact, the court's random case assignment algorithm has delivered you perhaps the most infamous and highly publicized case in Utah history. You may never preside over a more closely watched and heavily scrutinized case for the rest of your judicial career. You hardly slept a wink last night anticipating what's about to happen. Right now, it's 3 p.m., and as you prepare yourself to bring the court to order, before you, via CCTV, stands Tyler James Robinson, the man accused of the untimely demise of political influencer Charlie Kirk. You look over at Robinson and size him up. On the outside, there's nothing remarkable about him, except for his outfit, a green self-deletion protection smock. The outfit stands in stark contrast to the way the rest of the players in this scene are clothed. Your job today is mainly a matter of procedure. You'll read the charges brought by the state of Utah to Robinson and determine whether to grant him bail. Not that there is even a remote chance of that happening. He'd best get used to whatever his accommodations are over at the Utah County Jail in Spanish Fork. Robinson will also learn that the state of Utah is seeking the ultimate penalty against him. Though none of this should be a surprise to Robinson, the rules require it. And you're going to follow every rule to a T. There must be no error in this proceeding, no room for a verdict to be reversed on appeal. You say a little prayer and call the courtroom to order. Let's get this show on the road. Welcome to episode 4 of U of M Season 3. This season we are exploring the tragedy that took place on the campus of Utah Valley University, where political influencer Charlie Kirk was struck down in the middle of a public appearance on campus. This is episode 4, The People of the State of Utah versus Tyler James Robinson. This episode is all about the criminal case against Robinson. Something you may not know is that the raconteur behind this AI narration is a licensed attorney who has tried felony cases in the criminal courts of Cook County, Illinois. Using my experience and expertise, I will provide you with insight and analysis that few others can provide. What will be the prosecution strategy? What about the defense? Do they have a chance of saving Robinson from the ultimate sentence, despite what seems like overwhelming evidence? We will unpack all of this and try to make some educated guesses about the outcome of this case. By the way, if you're not familiar with the case, I don't know what rock you've been living under, but you can crawl out now and catch up by watching the first 3 episodes of this season. They'll bring you up to speed from the rooftop to Robinson's cell at the Utah County Jail. After this episode, we'll be turning our attention elsewhere, but we will be back with more updates as the case progresses. Don't forget to subscribe to get updates as Judge Graf drops his gavel. Utah's courts have a reputation for being firm and highly procedural in serious, violent felony cases. The sentencing requirements in the criminal code have strong mandatory components and do not allow for much flexibility. Judges and juries must abide by fairly high minimum sentences in major violent cases when compared with similar jurisdictions, and enhancement rules reduce discretion further. There is little room for leniency once a defendant is convicted. The state's sentencing framework emphasizes public safety and deterrence over rehabilitation in violent offenses, and prosecutors in counties like Utah County often pursue maximum or near maximum penalties, particularly in homicides or aggravated assaults. To the extent it even exists, judicial discretion toward leniency tends to operate within narrow bounds. The bottom line, in violent felony cases, courts in Utah, and Utah County in particular, maintain a reputation for strict sentencing, conservative application of mitigating factors, and limited tolerance for plea bargains that appear lenient. That's what Robinson is up against in this case. On September 16, 2025, Judge Tony Graf presided over Robinson's first court appearance. You may recall that Robinson wore the special smock meant to keep him safe. The first order of business for Judge Graf was making a determination that Robinson is indigent, which is a finding that the judge must make before an attorney can be appointed for Robinson. In Utah, a defendant may be found indigent if their income is less than 150% of the federal poverty guidelines. Based on what we know about Robinson's employment as a trade apprentice, the finding of indigent seems to be a fairly easy one for Judge Graf. And no, his parents' wealth and income are not taken into account, as Robinson is over 18. Next, the prosecution requested the entry of a protective order in favor of the victim's widow, Erica Kirk. Judge Graf granted the motion, which is a routine matter. The point of the order is to prevent Miss Kirk from any contact by Robinson. The prosecution then announced their intent to seek the ultimate penalty. That indication triggers certain statutory requirements pertaining to Robinson's defense. In a capital case, the defendant must have 2 lawyers appointed, 1 lead counsel and 1 co-counsel, and there are certain qualifications and training that lead and co-counsel must have in order to be appointed. The defense is also entitled to certain additional resources, such as experts and investigators to which they may not otherwise be entitled. It was at this stage that Judge Graf read each of the charges against Robinson.
Mr. Robinson, for count 1, aggravated murder, a capital felony in violation of Utah Code annotated 76-5-202, in that on September 10th, 2025 in Utah County, the defendant, Tyler James Robinson, intentionally or knowingly caused the death of Charlie Kirk. Count 2, felony discharge of a firearm causing serious bodily injury. Count 3, obstruction of justice, in that on September 10th, 2025 in Utah County, the defendant, Tyler James Robinson, conceal or remove the firearm used to shoot Charlie Kirk. Count 4, obstruction of justice, in that on or about September 11th, 2025 in Utah County, the defendant, Tyler James Robinson, destroyed, concealed, or removed the clothing he wore during the shooting. Count 5, tampering with a witness, in that on or about September 10th, 2025 in Utah County, the defendant, Tyler James Robinson, attempted to induce or otherwise cause his roommate to withhold testimony, information, a document, or an item, to wit, directing his roommate to delete incriminating text messages. Count 6, tampering with a witness, in that on or about September 11th, 2025 in Utah County, the defendant, Tyler James Robinson, and attempted to induce or otherwise cause his roommate to withhold testimony or information, to wit, directing his roommate to stay silent if the police questioned the roommate. Count 7, violent offense committed in the presence of a child, in that on or about September 10th, 2025 in Utah County, the defendant, Tyler James Robinson, committed criminal homicide in the physical presence of a child younger than 14 years of age, with knowledge that a child was present and that may have been seen or heard the commission of the criminal homicide.
Robinson was stone-faced during the proceeding. His facial expression revealed nothing more than a few slight nods of his head in acknowledgement that he understood Judge Graf. With the court's business of the day completed, Judge Graf continued the case to September 29, 2025. The County Commission did not waste any time appointing Robinson's lawyers. On September 20th, 2025, Catherine N. Nestor was formally appointed as Robinson's lead defense attorney. With Robinson already having been found to be indigent by Judge Graf, the county is required to fund his defense, an expense projected to exceed $1 million before trial even begins. Nestor has impressive credentials. She's a 30-year courtroom veteran, a former federal public defender for the District of Utah, and a fellow of the American College of Trial Lawyers, a credential few attorneys ever reach. She's tried more than 60 jury cases, including capital murders, and has led defender offices in both Utah and San Diego. She's joined by Michael Burt and Richard Novak, both nationally recognized death penalty specialists from California, granted special permission to practice in Utah for this case. Together, they form a formidable team. When reporters asked about her appointment, Nestor downplayed the attention. "We have a very good and cooperative defense bar in Utah," she said. That was her public face. Calm, pragmatic, almost detached. But her courtroom record tells a different story, one of calculated defiance against long odds. In a way, this defense team with that kind of skill, experience, reputation, and funding is exactly what the prosecution needs as well. Robinson will be hard-pressed to say that his defense was set up to fail with the resources that are being provided at his disposal. By late September, Nestor and her co-counsel had met privately with Robinson inside the Utah County Jail. From that point forward, the case belonged as much to them as to him. The paperwork had started. The discovery clock was ticking. And the defense, the only thing standing between Tyler James Robinson and a possible capital sentence, was officially in motion. On September 29, 2024, less than 2 weeks after court date 1, Utah v. Tyler Robinson was back up on Judge Graf's docket. Once again, Robinson appears via CCTV, not in person. Present in court before Tony Graf were the team of prosecutors tasked with convicting Robinson and Robinson's newly appointed defense team. The hearing was short. The court formally recognized the appointment of counsel. Prosecutors reiterated that their evidence was substantial, thousands of pages of discovery, hundreds of digital files, hours of video, and that they were in the process of preparing the discovery material to be handed over to the defense team. Nestor addressed the court next, acknowledging that they had not yet received the discovery and that once received, they would need time to review those materials. She also indicated that the defense would not be waiving Robinson's right to a preliminary hearing. However, she requested that a hearing date not be set until they had a better idea as to how much time the defense team would need to review the large volume of discovery material in preparation for the hearing. At this point, you may be asking, what's a preliminary hearing, and why would it matter whether Robinson waives his? Well, a preliminary hearing is a proceeding held early in a criminal case to determine if there is probable cause to proceed to the next stages of the case. On the one hand, if a defendant wins at a preliminary hearing, the case is over. However, in practice, it is a very rare occurrence for a defendant to win a preliminary hearing. The prosecution's burden of proof is very low. You may recognize the term probable cause as being used to describe the standard for a police officer to make an arrest. That's not a coincidence. So unless you have a reason to believe the defendant was arrested without probable cause, don't expect the defense to prevail at the preliminary hearing. However, having a preliminary hearing, even if you expect to lose, can provide a strategic advantage for a defendant. For example, if you think a case will likely go to trial, having a chance to cross-examine prosecution witnesses early on gives you an opportunity to poke holes in their stories or damage their credibility. On the other hand, if a case looks likely to end in a plea, you may waive preliminary hearing as a demonstration of goodwill to get a better deal from the prosecution by playing nice. There are many, many other considerations in deciding whether to waive preliminary hearing. But let's get back to our case before we completely lose the plot. Judge Graf agreed to hold off on setting a hearing date for now, acknowledging the need for time to receive and review discovery. He then set the next status conference for October 30th, 2025, acknowledging the complexity of what lay ahead. On October 9th, Robinson's attorneys made their first tactical move, filing a motion asking that Robinson be allowed to appear in court dressed in civilian clothes rather than jail attire. The motion cited constitutional due process concerns, arguing that parading a defendant before cameras in a bright green self-harm prevention smock risked undermining the presumption of innocence. They also noted the unique intensity of the media coverage, the cameras, the screenshots, the social media commentary, all of it shaping public perception long before a jury was ever seated. The prosecution didn't oppose the request outright, but asked the court to ensure that security protocols remained in place. Sheriff's deputies wanted the right to keep Robinson restrained, shackled at the waist and ankles, citing risk and policy. The matter noticed for presentment on October 27, 2025, and during a short virtual hearing before Judge Tony Graf, Robinson appeared once again by CCTV from the Utah County Jail, flanked by his defense team on a split screen. His lead attorney, Catherine Nestor, made her case for street clothes. "The state gets to present its case with all the advantages of authority," she said. "The defense should not be forced to present its client in a way that presumes guilt before a single word of testimony has been heard." Prosecutors countered that the court should balance appearance with safety. Robinson, they said, remained a high-risk inmate, accused of a violent public crime. Any relaxation of restraints, even for optics, carried real danger. After a brief recess, Judge Graf issued his ruling.
Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted.
Robinson would be permitted to appear in civilian clothing at all future hearings, but he would remain restrained while in court. The judge also issued a protective order, barring any photography or video of those restraints, ensuring the public would see a defendant, not a prisoner. It was a small procedural victory for the defense, but a symbolic one. From now on, every appearance Robinson made in court would be carefully curated. His clothes, posture, facial expressions, all part of a long game meant to preserve the image of due process and possibly save his life. The judge also set some future dates in the proceeding. Preliminary hearing is set for January 16, 2026. An arraignment, when Robinson will enter his plea, is set for January 30, 2026. By this point in the case, the state had what prosecutors like to call a mountain of evidence. The weapon, admissions by Robinson to his partner, his Discord friends, and police. Surveillance footage, ballistics reports, digital records from Robinson's phone, laptop, and social media accounts. Interviews, forensics, expert analyses. Every piece collected, cataloged, and stored in the evidence locker at the Utah County Attorney's Office. But evidence is only power if it can be used. In the months ahead, the prosecution's job will be to make sure that every admission, video, photo, file, and piece of physical evidence survives the gauntlet of pretrial motions. That means proving the chain of custody, authenticating every digital record, fending off suppression motions from Nestor's team, who will argue that some searches went too far, some statements were coerced, or that some data was obtained without a proper warrant. The first battlefield isn't the jury box, it's the filing cabinet. If the state clears those hurdles, the case will eventually move into two distinct phases: guilt and penalty. In the guilt phase, prosecutors will present their evidence to prove beyond a reasonable doubt that Robinson planned and carried out the demise of Charlie Kirk. But their eyes are already on the second phase, the one that will matter most. The penalty phase is where the same jury must decide whether Tyler James Robinson should be prematurely ended. Under Utah law, that decision will be made by a jury, and it has to be unanimous. One juror's hesitation is enough to spare his life. So the prosecution is already preparing for that moment, building not just a case, but a story. A story about intent, ideology, and the deliberate targeting of a public figure. They'll highlight aggravating factors, that this was premeditated, carried out in a public place, and placed countless others in danger. They'll frame Robinson as a man who wanted to make a statement through violence, a crime meant not only to forever silence Kirk, but to send a message. When the day comes, they'll show the jury the faces of those who were there, the chaos in the crowd, and the lasting damage to a family and a community. In that phase, the evidence won't just be about bullets and data. It'll be about loss, grief, and what the state calls the ultimate accountability. For now, the prosecutor's task is simple and exhausting. Preserve the evidence, protect the record, and prepare the narrative that could lead a Utah jury to do something it hasn't done in years. Vote unanimously for the ultimate punishment. If the prosecution's plan is to build a mountain of evidence, the defense's job is to chip away at it. One motion, one objection, one microscopic flaw at a time. From the start, Catherine Nestor and her team have signaled that they intend to scrutinize every step of the investigation. How the warrants were obtained, how the digital evidence was collected, how the chain of custody was handled, and whether any of it crosses the constitutional line. Expect a wave of suppression motions, challenges to the admissibility of Robinson's phone data, his online activity, and statements he made to law enforcement. Every search warrant will be tested for overreach, every witness interview reviewed for coercion or contamination. In a capital case, it's not about throwing sand in the gears. It's about finding a single procedural crack large enough to cast doubt on the foundation of the state's story. Nestor knows this terrain well. As a former federal public defender, she's built a career on identifying weak spots: the stray metadata, the incomplete chain of custody, the missing timestamp, anything that can make a jury hesitate. And if the evidence survives, her focus will shift from what happened to why. Because in a capital case, guilt is only half the battle. If or when the case reaches the penalty phase, the defense's task will no longer be to deny what happened, but to argue for life over death. That's where mitigation comes in, the process of humanizing a defendant in the eyes of a jury that has already found him guilty. The defense will present evidence of Robinson's background, upbringing, mental health, and psychological state. They'll call expert witnesses, psychiatrists, trauma specialists, perhaps even family members, to explain how a lifetime of instability, ideology, or untreated illness may have led him here. They'll argue that an eye for an eye would serve no purpose, that it would silence the possibility of understanding why this happened. They'll remind the jury that Utah hasn't ended anyone in 15 years, and that life without parole would confine Robinson to a cell for the rest of his natural life. Punishment enough. Their job, at that point, is to find one juror, just one, willing to see something salvageable in Tyler James Robinson. Because even if the jury has 11 votes for capital punishment and 1 for mercy, it means that Robinson's life will be spared. And Utah does not allow a judge to override the jury's decision. So it just takes one merciful soul to spare Robinson from the worst. Nestor's team knows that Robinson facing a group of Second Amendment enthusiasts isn't just a legal outcome. It's a symbol. It's the state's most final form of justice. And their mission, from the first motion to the final appeal, is to make sure that day never comes. One final thing to consider is the nature of Robinson's confinement leading up to and during trial. Something that folks may not fully appreciate is that the worse the conditions Robinson experiences, the more tempting it may be for him to consider a guilty plea. At present, Robinson is being held at the Utah County Jail in Spanish Fork, a beige concrete maze sitting just off Main Street, tucked between farmland and freeway. It's where most of Utah County's pretrial detainees who can't make bail or are not granted bail wait for their day in court. Some are there for a few weeks. For detainees like Robinson, well, they best start getting cozy. Jail officials haven't said exactly where he's housed, but in a case like this, capital charges, media attention, threats swirling online, it's unlikely he's walking the same corridors as everyone else, i.e., he's probably not housed on the main line. High-profile defendants are often flagged as special management inmates. That means limited movement, escorted transfers, and a small rotation of deputies assigned to supervise them. In Utah County, that can look like protective custody or administrative segregation. A quiet wing with rows of single cells, 23 hours locked in, 1 hour out for shower or exercise. Meals slid through a slot in the door. Lights that never quite go out. Sometimes, protective custody isn't about protecting the public from the inmate. It's about protecting the inmate from the public. There's been no official confirmation, but sources inside the jail system tell us Robinson was placed under enhanced observation when he first arrived, a precaution that can include a self-harm prevention smock, like the one Robinson was wearing during his first court appearance, constant monitoring, and no access to standard jail clothing or personal items. In a case this volatile, suicide watch isn't punishment, it's procedure. The Utah County Jail itself isn't designed for long-term confinement. It's an inhospitable place with bare concrete walls, fluorescent lighting, and the endless hum of ventilation and the slamming of steel doors. This is where Robinson will sit, day after day, while the state builds its case. His world reduced to 70 square feet and a flickering television tuned to the news. Or not. Suffice to say, his stretch at Utah County will not be an easy piece of time. The legal gears are now turning. Over the next few months, expect a flurry of pretrial motions, challenges to evidence, debates over witnesses, disputes about what the jury will hear and what it won't. Every motion, every ruling will shape the trial that's coming. When that trial begins, the questions will shift from what happened to why it happened. And when it ends, the courtroom will face its hardest decision yet, the penalty phase, where 12 Utah jurors will decide whether Tyler James Robinson spends the rest of his life in prison or faces a group of Dick Cheneys on a hunting trip. This case is far from over. It's only getting started. We'll be following every hearing, every motion, and every revelation leading up to the trial. In the meantime, we're taking a short break to catch our breath, just a couple of weeks off the posting schedule. And then we're back with Season 4 of University of Murder. If you haven't already, hit subscribe so those bonus updates and follow-up episodes drop right into your feed as soon as they're live. And prepare yourself to learn which institution of higher learning we visit next. And if there's a case you think deserves the University of Murder treatment, one we should dig into next, tell us. Leave a comment, send a message, or drop it in the reviews. For now, this is University of Murder, Season 3, Episode 4. The State of Utah versus Tyler James Robinson. We'll see you in court.